Okay, I hope everybody has been having a good day so far and enjoying your first morning program. We are looking forward to both this program and then our keynote at noon with Dean Erwin Chemerinsky. So we've got some good stuff planned. And then we also have a bonus program this afternoon, which is a marketing support, learning about marketing for your law firm. And that's at 2 o'clock. So good stuff planned. Okay. Let's see. Just waiting on a couple more people to come in. And then we'll get started. Oh, looks like we still have one of our live Q&As from an earlier program still going on. I'm sure they had a ton to talk about with the solo and small firm one. So we're just going to wait another couple of minutes so that everybody gets a chance to hop in, and then we'll get started.
I'd put on music, but I don't think everyone would like mine. No.
Hi, you ready?
All right. Oh, wonderful. Vanessa, you're here. Thank you. And I apologize for some of those technical difficulties. I will just rename you here. Okay. All right. And you are on, Vanessa. Thank you.
Wonderful. So hello, everyone. My name is Vanessa Berry, and I am the chair of the Contra Costa County Bar Association's Diversity, Equity, and Inclusion Committee. And I hope you are enjoying, as much as I am, the 27th annual NCLE Spectacular so far. As a reminder of what's coming up, our keynote speaker today at 12 noon is Dean Erwin Chemerinsky, who will be discussing the internet and its relationship to democracy. But for now, I would like to welcome you to this session, which is called Inclusivity in the Workplace, Best Practices for Creating Safe Spaces for Persons Living with Disabilities to Self-Identify. So we're really excited to bring this session to you live. So we look forward to your active participation as it is designed, and we hope for it to be interactive. The program is presented by the Disability Rights Subcommittee of the Contra Costa County Bar Diversity, Equity, and Inclusion Committee and the Contra Costa County Bar Association Employment Law Section. Our sponsor for this session is the Venegas Law Group, and I would like to introduce Marta Venegas, who is a shareholder with the Venegas Law Group. And Marta, I'd like to invite you to say a few words.
Thank you. As you said, I'm Marta Venegas, shareholder of the Venegas Law Group. My pronouns are she and her. As you can guess from this, I'm a civil rights, employment, and business law attorney. We are a litigation boutique specializing in employment, business, and general civil litigation. Our clients are typically minorities, women, and people with disabilities who come to us on one of the worst days of their lives. We help individuals and small businesses navigate the complex California legal landscape so they can get closure and move on with their lives successfully. As the coronavirus pandemic unfolded, it exposed our society's many failings in how we treat our fellow countrymen. Disability discrimination became rampant, and it frightens both employees who need accommodations and employers who are required by law to provide them. The presenters of this session will enlighten us on the very important first step we must take to combat discrimination of any kind, creating an open society where communicating our difficulties and differences is the normal and not the exception. I strive to live in a society where being vulnerable is not seen as a weakness, but is welcomed and embraced. I am confident that after this presentation, we will be better equipped to listen to each other. For these reasons, the Venegas Law Group is delighted to sponsor this presentation. Please note, any mistakes in the presentation are mine only. And now, here is the show.
Thank you, Marta, for providing that context for the program and for your sponsorship and continued support of the Bar Association, and specifically for this event. The commitment of your firm is definitely coming through in your words. So as everyone knows, our event and program sponsors are key to what we can accomplish and are a very important part of the Bar Association community. It is our sponsors that make it possible for us to provide events like this. So please support us by supporting them. And in moving forward, as a reminder, for any assistance during the program that you need with technical difficulties, just go to the FAQ support tab on the events main page, and you will be given assistance. And at this time, without any further ado, I would like to pass the program over to Julie-Ann Giammona. And Julie-Ann is the program moderator, and she will introduce the presentation and her fellow speakers. Take it away, Julie.
Thank you, Benisa and Marta, also for that wonderful introduction. Good morning, everyone. Happy to see that you've joined us here today for this very important topic, how to create safe spaces for persons living with disabilities to self-identify in the workplace. My name is Julie-Ann Giammona, and I'm of counsel with Ferber Law, and I chair the subcommittee for Disability Rights, DEI Committee for Contra Costa County Bar. In 2020, the California State Bar issued its first ever report card on diversity. The report noted that 22% of people living in California identify as living with a disability. Yet only 5% of lawyers reported same. Of those lawyers that self-identified as living with a disability, they consistently reported low satisfaction with workplace experiences, including advancement opportunities, career development, and salaries. My hope is that today's discussion opens a lasting conversation and sparks ideas for action steps moving forward to increase inclusivity in the workplace for lawyers living with disabilities. I am one such lawyer who lives with an invisible disability, a disability that is not immediately apparent when you first meet me, giving me the opportunity to hide behind a smile. My experience disclosing my disabilities has been met with mixed results. I've lost significant personal and professional relationships due to a lack of understanding of what it means to live with an invisible disability. I've also experienced resistance from both judges and opposing counsel when requesting necessary accommodations. Despite this loss, I have gained so much more. The knowledge that power comes from using my voice to raise awareness on this important topic so that the next generation of lawyers can practice amongst other lawyers, judges, and clients who reject exclusion in all of its forms and instead create safe spaces for lawyers living with disabilities to succeed and thrive. I am absolutely thrilled today to present to you an amazing panel of speakers. We have Branden Butler, who is the Assistant Deputy Director of Education and Outreach for the California Department of Fair Employment and Housing. We have Wendy Musell, who is Managing Partner of Law Offices of Wendy Musell and of Counsel to Levy Vinnick. We also have Beth Mora, who's going to jump in and out as we need her. One of our speakers had to cancel at the last minute, unfortunately, and we grabbed Beth in, and so she's going to be ad hoc. She's going to jump in as she can. So what we have planned is each of our speakers are going to probably speak for 15-20 minutes, and then we're going to have an interactive session for probably 30 to 40 minutes. And this was our goal for our presentation, the reason we're doing it live. We've created hypotheticals, and we thought for this kind of a presentation that we can all join in, read the hypos, and then all discuss so that we can learn different tools from one another as how to handle these situations when they arise. So of course, we are offering MCLE credits for this presentation. So I think I'm supposed to tell you to make sure you stay on until the end if you want your credit. So don't sign off even if you get bored with us. Stay on so that you can get your credit. So I am not sure if Branden, let's see, I'm not in the chat. Have you checked the chat, Beth? I'm not sure. Okay, so we have we're waiting for, Branden Butler is our first speaker. He agreed to join us, even though he's literally coming from another presentation where he's presenting right now in Monterey. So he is going to be about another couple of minutes. So I am going to let Beth, do you have anything you wanted to say about this presentation before we introduce Branden?
Real briefly, I wanted to share with all of you why we thought this session was so important. Because if you look at the statistics for the state bar of who's licensed attorney in California, we as Californians, we have over 190,000 licensed practicing attorneys in California. We are aging. I think that's lovely. I think when you age, you get a little shorter. So I don't stick out as the shortest person in the room. So I appreciate that. And thank you very much. But we as our population of licensed attorneys are aging. And statistically, when we age, we actually age into disability. So part of what we're going to talk about today and the importance of self-identifying is because we are not just aging, we are aging into disability, that it is very common for attorneys to brag. I texted my client from the ER after I broke my leg. It's a badge of honor to be strong. And it is actually a sign of weakness to admit illness or disability. But it is a protected class. It is something where even the Chief Justice and the Supreme Court has said that we have to stop and pause when we're disabled. It could be an ethics violation if not. And we have to recognize that our population can age into disability. It is more so happening, and it will keep happening. And we have to recognize it together. And we have to recognize in our discussions, in our DEI discussions, in our firm discussions, that this is who we are and who we are becoming, and not label it as a weakness or a negative, but also as a positive, because it creates diversity. It is not a negative as to who we are. And so we'll talk about that more, but I do want to flag for you as you look at your diversity speakers policies. A lot of them don't even list disability as a protected classification or a diverse population. There are things that we need to just look at as we talk about this as we move forward. So just remember, if you don't actually think of yourself as disabled, you might want to watch some of these things that we're talking about, because you may be and not even realize it, because we are trained as attorneys to always be in fight mode. And it may be that we've been trained not to see ourselves correctly. And that's why we're talking about this today.
Thank you so much, Beth. We appreciate you jumping in and having you here and your knowledge and expertise. Thank you. Wendy, do you want to go ahead and start? And then we'll let Branden follow you since he's just running a little bit. He's still on stage. So would you like to go ahead and start?
I would be happy to. Beth, do you mind pulling up the PowerPoint? First of all, I'm Wendy Musell. I'm a partner at the law offices of Wendy Musell and also of counsel to Levy, Vinnick, Burrell, Hyams in Oakland, where I'm thrilled to practice law on behalf of employees. I've been representing employees for the entirety of my career since 1999. I've represented many people with disabilities. I'm a person with a disability. I also am a woman and LGBT. So like many of us, we fit into the intersectionality of these different protected statuses. And I think that's something that's important to recognize as well, is the intersectionality for people with disabilities cuts across all races, national origin, sexual orientation, etc. And so I am thrilled to be here today to talk about these issues. I'm going to be focused on a couple of things. And
I'm just going to interrupt here for a second because I don't think that, can you go past all, I think Wendy's probably like number 27 or 28 on the slides. Thank you so much. Apologize for this to all the attendees. We're just trying to.
Great. Thank you.
Perfect. Thank you.
Great. And next slide, please. So the areas that I'm going to cover today is the State Bar Diversity Report Card. And in the State Bar Diversity Report Card, they did have very practical ways to address workplace deficiencies for attorneys with disabilities, as well as other categories of attorneys. And so we're going to be covering a lot of that today. As Beth had indicated, the aging population of the bar and how that also interacts with disability status. We're going to briefly talk about COVID, which is, as we all know, has changed the practice of law in the world as we know it, and provided a lot more awareness regarding disabilities issues than I think occurred before, and a lot more discussion than occurred previously. Briefly, we're going to cover the studies regarding hiring people with disabilities and how positive they are, and also the culture problem within the law, and how ableist it is, and hyper, get it done no matter the cost. So we're going to start first on the next slide with the report card on diversity of California's legal profession of the California State Bar. I encourage everyone to take a look at this report card. I think it was an incredibly well done report. I will say that the language that's in the PowerPoint is the language that's utilized within the report card. And I also acknowledge the issues of intersectionality, meaning that people with disabilities are often in many of the categories regarding diversity. The report card did reflect issues regarding attorneys living with disabilities, but don't necessarily reflect that those attorneys could also fit within other areas of diversity. So the report card on diversity, what they did is that they sent out a request for information from all members of the bar and received many responses. And what they were looking for, generally speaking, is how do you feel about your legal practice? Are there particular areas, particularly in related to diversity, that are of concern? And where does that shake out demographically? As it relates to people with disabilities, just looking at the number of individuals with disabilities, as is previously indicated, 20% of Californians report at least one form of disability. And we're using the definition of disability under state law that limits a major life activity. So this is from the report, they indicated that limits activities and self-care. This includes the gamut of disabilities, mobility issues, cognitive impairments, vision or hearing impairments, for example. By contrast, as had been previously indicated, only 5% of attorney respondents reported living with a disability. And that's an interesting differential that the general population is indicating 1 in 5, whereas attorneys are 95% are disclaiming that they live with a disability. I think that indicates a lot of attitudes that are with the bar concerning who are individuals with disabilities, the abilities of attorneys with disabilities, and discriminatory thoughts and approaches as it relates to individuals with disabilities. I think as a profession, we have a long way to go, and the report card reflects that. Next slide, please. So the report card looked at and obtained information regarding satisfaction with career development opportunities and workplace experiences, and also looked at retention issues. And so what the State Bar asked is individuals, if they're satisfied with various aspects of work life, including pertaining to their individual careers, as well as their experiences in the workplace. This covered the wide variety of workplaces in the law. So this could be large firms, small firms, plaintiff side, defense side, all areas of law. It covered judges as well, individuals who are active members of the State Bar, as well as inactive members of the State Bar. And the results were based on composites derived from survey questions within each of the workplace domains and particular identified areas of diversity, including people with disabilities. Again, note that as with many of the other categories of diversity, there's intersectionality that individuals will fit within in multiple categories. And they looked at the levels of satisfaction in the workplace as compared with white men. So the first area of satisfaction was individual career and workplace issues. And of all the categories of diversity, people with disabilities indicated the lowest level of satisfaction of 44%. And this included areas of advancement opportunities, so the ability to promote and get in positions of power in the workplace, career development opportunities, the assignments that are provided to them in the workplace, the respect and prestige that they enjoyed in the workplace. It looked at salary, and it also looked at performance evaluations to the extent that those were performed. Next slide, please. And then they also looked at the collective workplace issues. So setting aside the individual experience, but where they saw the organizational development was, or the culture of their law firms or places of work. This also included attorneys who work for public employers. And again, people with disabilities scored the lowest satisfaction rate of any group, including in the areas of mentoring, for having coworkers for which they felt supported by, support by leadership, a commitment to diversity in the workplace and inclusion in the workplace, and also related to the application of anti-discrimination policies, meaning do they walk the walk and talk the talk? So if there's an issue that arises, an EEO issue of discrimination, harassment, or retaliation in the workplace, are they actually applying anti-discrimination policies and indeed even have them? Next slide, sorry, excuse me.
No worries, complex.
Pardon me. The next area that they looked at was work-life balance. So this is the number of hours worked, flexible work schedule, so the ability to start later or to create your own schedule so long as you're performing the work. So the flexibility related to that. Flexibility also would relate to the ability to go to doctor's appointments or other needed treatment, for example. Maternity leave, paternity leave, or those were the terms that were used within the survey. So any parental leave, as well as family medical leave and child-friendly work environment. So people with disabilities and women of color were, that was the term that was used within the report, were tied for 43%. And the next area that the report card looked at, which I really appreciated, is given these percentages, which indicated across the board that there's remains issues regarding diversity in the legal profession. What do you do? How do you fix it? And so I personally greatly appreciated that the report card just didn't give us the bad news, things that we probably already would have surmised from our observations of the workplace, but also gave us tangible solutions in order to create a more inclusive workplace. So the first call to action was about workplace leadership. And it indicated that in order to turn around some of these areas, that there should be measurable and visible diversity and inclusion goals, and to set regular report and to discuss the progress. Meaning it's not enough to indicate that the workplace values diversity, but there actually has to be actions that are measurable and that leadership and organizations go back to determine whether those measurable goals are actually being met. And if they are not, why not? And if they are, why are they? So that you continue along that path. It also indicated that leadership needed to take an active role in advancing inclusion and diversity by participating in goal-setting efforts and holding employers accountable for results. So if the workplace is consistently falling behind, that there are identifiable reasons for that and actions taken in order to resolve that. So if there's particular supervisors that are at issue, if it's a lack of time or effort, if it seems to be simply lip service with no deliverables, that those things can be addressed in real time, so that it isn't, for example, once a year that the topic gets discussed and then shelved for another year to wonder why we have the same issues. Next slide. And the report card also asked whether workplaces had very specific deliverables to create an inclusive workplace. And this includes having established and clearly communicated criteria for advancement within your organization. This is particularly important if you want to have an inclusive workplace. How do people get promotions? How do they get those plum assignments? Is that transparent to the employees and associates, for example? How do you become partner? Are there particular criteria? How do you get on trials that are more high profile? In order to have a diverse workplace with leadership in diverse roles, those have to be clearly communicated and established criteria. Secondly, they asked, is there an institutionalized process to ensure that all attorneys have equal access to the resources and experiences needed to satisfy those criteria? I think that's a nice way of saying, is this an old boys network, for example? Are you giving the same sort of opportunities to all of the employees in your workplace, including employees with disabilities? For career professional development programs, do they align with your advancement criteria? So if you have specific enumerated, written down, available to everyone, criteria for advancement, are your professional development programs, your trainings, your mentorship, do those align so that all individuals who work in an organization have the opportunity for career advancement? For executive coaching or leadership training, are those opportunities available to all attorneys to develop and expand their skills, or only a small subset? Do you have to be in the know in order to obtain those services? Are those services provided equally, or is it a tap of the shoulder type of process? The last one was a mechanism to solicit feedback from attorneys as to the types of career development opportunities they would be interested in receiving. A lot of that feedback is extremely important to understand what would be necessary for attorneys to get to the next step in leadership, and what would be needed in order to provide to attorneys in order to get there. Next slide, please. And then the State Bar report card looked at work allocation that reflects the priorities for retention and advancement goals. I think this is incredibly important. A lot of this, in my experience, having worked, I've only worked on the plaintiff side, employment side, but even with the plaintiff side, where we're enforcing civil rights laws, I can say that even on the plaintiff side, you will find that sometimes these the goals of equal opportunity are not aligned with the practices. So in the State Bar report card, it did ask very specific questions. Regular reviews of how work is assigned, the effectiveness of mentoring and staff evaluations, as well as whether you're giving junior and mid-level staff the opportunities they require to succeed and advance in leadership opportunities. So this is really looking down at what work are you giving to your associates and employees to make sure that they have the opportunity to advance. And this, again, isn't providing opportunities solely to individuals that perpetuates a lack of diversity at the highest leadership levels. The next slide, please. The report card had a call to action regarding feedback. Is there a 360 feedback process so that individuals with disabilities, as well as individuals who are within other diversity categories, can explain or have an opportunity to discuss what is it like to work there? Are there issues? This is one of the easiest ways to find out, hey, do I have an institutional problem that I need to address? And then looking at salary and compensation. Does your salary reflect your values of equality in the workplace? Or are you finding that when you actually look at the salaries that, for example, men are being paid more than women, individuals with disabilities are also lagging behind on salary and compensation? Is there a differential based on race? And the ability to honestly review those issues and correct them. Next slide, please. As Beth indicated, the age of attorneys in California, this is from the State Bar website, and the average age of active attorneys is 49 years old. The average age of active judges is 61 years old. In terms of living with disabilities, as one ages, of course, these health issues may come up more often. And so I think what the age reflects is that, even more than other professions, our profession, we're lucky enough where we can work far later than perhaps other professions. And that also means that probably as a percentage of population, there's a greater percentage of individuals with disabilities who are attorneys. Next slide, please. There are many studies which discuss hiring people with disabilities and what those outcomes are on an economic basis. What the studies have demonstrated across the board is there are improvements in profitability for businesses that do hire individuals with disabilities, particularly with cost effectiveness of those employees, turnover and retention. I think the reason for turnover and retention being higher, keeping people with individuals with disabilities, that if you have an employee who is an individual with a disability and they're happy at their workplace, they're unlikely to jump jobs. And so there's a higher level of retention and turnover for employees with disabilities than there are for employees without disabilities. Reliability, punctuality, those were also higher when it came to employees with disabilities, as well as company loyalty and company image. For competitive advantage, they also found advantages for hiring individuals with disabilities to provide customer loyalty and satisfaction, innovation, productivity, work ethic, and safety were all higher statistically for individuals with disabilities. And also, of course, having an inclusive workplace and culture. And the final area is law has a culture problem. So I'm just as much to blame as anyone else as it relates to this. You know, working while I'm ill, working while my kids are in the hospital or my mom was in the hospital. Many of us have done this, you know, taking calls while we're dealing with health crises. And I think there's a culture of a badge of honor to do so. And part of that, it makes it even more difficult for individuals with disabilities to come forward and say, look, I need flexibility regarding time, for example, to go to an appointment, or I have particular areas where I may need, you know, leaves, or I may need other accommodations in the workplace. So I think when we look at that sort of toxic culture, that has many costs, not only to the individual, but also to the practice of law as a whole.
Thank you so much, Wendy. Appreciate you sharing that information. And I see that Branden Butler has joined us. Thank you so much, Branden. Are you there with us? I know you.
Yeah, yes, can you hear me?
Yes.
Yes. Well, thank you for your patience. I'm coming live from the Cal Perla conference in Monterey. So I just stepped off the stage into a little area here on the hotel grounds. So thanks for your patience, and looking forward to the discussion. And you know, I think it's a real important discussion because, you know, as I was preparing for this, I you know, hadn't really thought about it myself, but, you know, as an attorney, it is part of the culture that we don't identify as someone with a disability. There's a lot of reasons for that, like you said, with the culture and the ability to succeed in your career. And, you know, I myself am a person with a disability, and I never really, you know, used the law to my advantage when I needed help. You know, I would, you know, go into courtroom trials where maybe I was ill, maybe I needed to attend the doctor, put it off because you wanted to keep up with the crowd. And I think it's important for all of us as attorneys to realize that we should self-identify, and that there are certain protections that I'm going to cover that can really help us do our jobs even better and better for our own health. So Beth, if I could ask you to share the slides. I just don't want to disturb the limited Wi-Fi setting here. So
Perfect. Thank you.
Yeah, thank you. So we can go to the next slide. Appreciate that. Now, most folks I'm sure here know, but if you don't know, you know, I'm the Assistant Deputy Director of Outreach and Education at DFEH, and you know, we're California Civil Rights Agency. That's our mission is really to protect everyone, including lawyers, and you know, everyone from discrimination in many of our areas of jurisdiction. And I'll go to the next slide. And I think most folks here probably know us, right? We're the place where we receive thousands of complaints for employment discrimination, housing discrimination, labor trafficking, you know, UNRRA violations for public access discrimination, and the Ralph Act. So we do a lot of that, but we also facilitate resolution through mediation. And then we also enforce California civil rights laws by filing, you know, lawsuits in civil court. Next slide. And you can go next slide. Thanks, Beth. So, I mean, I think, you know, I'm showing this slide just to kind of give us an orientation of when we think about discrimination, when we think about employment discrimination, who's protected. And you see all the various protected bases here, but I just want to, you know, highlight, of course, that persons with disabilities, whether physical or mental, are protected under our laws and protected in every area of employment, not just, you know, I think for attorneys, we think we're somehow not part of this and we're separate, but no, we are in this. And, you know, hence why it's so critical to be able to identify as a person with a disability to protect yourself from discrimination. Next slide. And I think the takeaway here is that, in 2019, and I know it's almost 2022, but this is the only public data we have available to share with you today. But, just take a look at the numbers that, persons with disabilities have filed the, most complaints generally for employment discrimination. And it's been that way, almost every year. Sometimes age comes up, but generally persons with disabilities have faced the highest levels of discrimination, or have alleged that. And so, our office investigated 5,183 employment filings. There was a total of 16,000 bases of discrimination alleged, right? Because you could say disability, race, gender, sexual orientation, right? One complaint could have 4 or 5. But we also issued 15,076 right to sue letters. And a right to sue letter means your DFH will not investigate the case. The complainant has alleged to go directly into court. And we issue those immediately. And we issued 15,000 of those. And next slide, please. And actually, again, you see the numerical value of disability up to, almost 2,868 bases of discrimination alleged for disability. So again, very high, and I think really important for our conversation today. Next slide. And I'll go to the next slide because I want to get into a couple of media things. Now, this slide I wanted to show you because this is the 15,000 right to sue letters that we received at DFEH, right? We didn't investigate, they got the right to sue letter, went into court. And again, you'll notice that persons with disabilities is the highest protected area alleged for discrimination for a right to sue letter. So I just think it's important that what's happening outside in other forms of employment is actually what's happening in the legal profession as well, right? We're not immune to these trend lines in California and also nationally, these trend lines, which are very much similar. So just, the takeaway here again is that the issue of disability-based discrimination is a major issue. And as Wendy pointed out, it's going to be ever increasing as more and more attorneys work into older age, and disabilities and things are going to pop up, and the need for accommodations are going to be needed. So it's really going to keep growing. Next slide, please. So I think the first stop, just is in terms to orient ourselves of the law of, okay, so we've said, that folks with disabilities have protections in the workplace. Where does this come from? Well, it comes from the Fair Employment and Housing Act. And, but to start off by saying this, that, the FEHA, the Fair Employment and Housing Act, applies to all employers with 5 or more employees, right? And if that's, anywhere where, attorneys working in a firm or, small firm, even boutique, they're going to be covered under this law. And that means that the employer is going to have to provide reasonable accommodations to individuals with a physical or mental disability to apply for jobs and to perform the essential functions of their job, unless it would cause an undue hardship. So that's a major right when you think about it, that if you are a person with a disability, you can request a change, in the work structure to allow you to do the essential functions of your job. That's going to allow you to be really equal to someone without a disability. That's really what's happening here, right? Unless it would cause undue hardship, which we'll get into a little bit more. Next slide, please. So the FEHA on disability. So broadly, right, the Fair Employment and Housing Act protects against employment discrimination and harassment based on a person's disability or perceived disability, right? Someone may not even be disabled, but they're perceived as having a disability and face discrimination. The FEHA also prohibits retaliation for exercising a right, such as filing a complaint about discrimination or even asking for a reasonable accommodation, right? You ask for reasonable accommodation, and the next thing someone wants to reduce your hours or give you a different type of job that's of lower function, right? That's retaliation because you even asked. And the FEHA does require employers to accommodate individuals, right? Unless the employer can show that to do so would cause undue hardship. And again, we're going to talk about undue hardship, but it's not like you can just say it and therefore you never have to grant an accommodation. It's actually a pretty stringent requirement. Next slide, please. And I think it's also important, and this I think is key, which is that, even if your condition is not presently disabling, right, you still are a person with a disability, which means having a limitation to a major life activity. I'll show that in another slide. But this is a key point. It also does cover medical conditions, which are defined as cancer and genetic characteristics as well. So that's kind of covered in that boat. But a disability does not include like any type of sexual behavior disorder or compulsive gambling or kleptomania or pyromania, or these are things from the regulations. They don't necessarily I think it's fairly decided, but also want to point out too that if you're using illegal drug use, right, and this does impact lawyers, that's not being disabled. But if you're no longer using any illegal substances, you can be a person with a disability, right? So that's important to remember as we think about substance abuse for lawyers. Next slide, please. So I always want to break this down because a lot of us have, like, as lawyers, we've heard about the Americans with Disabilities Act and what's this and how does the FEHA interact with it? And there's a lot here, but I think just one takeaway from this slide is to know that California law, the FEHA, has broader definitions of disability than our federal law does. Under the Americans with Disabilities Act, someone's only disabled if it involves a substantial limitation to a major life activity. Under California law, it's just that the disability must only limit a major life activity. And this was actually a fairly large amendment that happened in the early 2000s to the FEHA, and was really important because it did open the door. And I think as we think about self-identifying, we often think of, a person with a disability is only someone who's significantly disabled and has a live-in aid and is using an assistive technology device. But no, it's very broad. And I think as lawyers, we definitely don't think of ourselves in that way, but the definition of limitation is broad. And so I think it's important to understand that this is a broader definition that we may have constructed in our mind. And whether a condition or disability limits major life activities is this is also key, is determined regardless of any mitigating measures, such as medication or prosthesis or any mitigating measures. And I bring that up because, as I said earlier, I'm a type 1 diabetic. I wear an insulin pump. And, if everything's going right, I do my thing. I feel, just fine. But if I didn't have my pump, I would die. To put it really very starkly. So even though I'm using a device, I'm still underlying have a disability. And I just, point that out again, that just because we may have our condition very well managed, as many lawyers, we are in control, it still doesn't mean that we don't have a disability. Next slide, please. And remember, the key to this protection, right, not only being protected from discrimination and also having the right to request an accommodation, is really one of the key parts of the FEHA, right? And what is that? A reasonable accommodation is where, in this case, we're talking about lawyers, is going to be asking to have some type of change or modification made that's going to allow the individual to really carry out the functions of their job. And it's going to be effective enabling the employee to perform the functions, enable the person to actually apply for the job, and also it's effective enabling the employee with the disability to enjoy the equivalent benefits and privileges of employment as similarly situated people without disabilities. And again, this is one of those times when we think about discrimination, we're thinking about fairness, treat everyone the same. But when we talk about disability, we are actually making an exception for someone with a disability, because we have to make the exception in order to get them to be equal to someone without a disability in the workplace. So, as you think about, you've been hearing the panelists talk about in the attorney field, how powerful this tool could be of, getting a change to perhaps your assignment or a change to your hours that may be, necessary for your disability. It's really a powerful tool. Next slide. And some examples of accommodations, I think in the regs you'll see, are going to be allow employees to bring an assistive animal to the workplace, transferring an employee to a more accessible work site, job restructuring or reallocation or of essential job functions, right, to a job with multiple responsibilities, providing a part-time or modified work schedule is another example. Adjustments to any kind of training or examinations that are done, and modifications to policies, working from home, of course, which has been powerful. And I'll just mention from the New York Times columnist Thomas Friedman, who published an article this year around the pandemic, really looking at how, while the pandemic has been very severe and caused so much harm throughout our country, if there was any silver lining through this, has been that it's really been a revolution for persons with disabilities who have been able to work from home and have been able to show that they can excel from home, and can really maybe be the revolution that persons with disability have been looking for so long, because they face such high levels of discrimination in the workplace. But now that everyone is accepting and understanding the power of working from home, it really does open a new door, and perhaps will allow us as attorneys to use this function more in our workplace for persons with disabilities. Next slide, please. Now, I talked about undue hardship. So when can the employer, when can the firm manager say no? We're not granting the accommodation. Well, an accommodation, it is going to be reasonable if it does not impose an undue hardship on the employer's businesses, and an action requiring significant difficulty or expense incurred by the employer or other covered entity, when considered under the totality of the circumstances, can equal an undue hardship. It's not just that there had to be any amount of money spent or any amount of difficulty. That's going to be expected, but it's really looking at the significant difficulty or expense. Again, the totality. Is this a large firm with a lot of resources? Is it a very small firm, very few resources? So you kind of have to go through this totality exercise. But there is a way to deny an accommodation. In some cases, it may be denied. Next slide, please. And some of the factors that we look at in the regulations for what's an undue hardship are going to be the nature and net cost of the accommodation. How much it's going to cost, the overall financial resources of the entity involved. How many people work there? Because that goes into it. Very small, or there's a lot of folks, and they could handle the extra work or the division of labor. We're looking at the size of the business, how much earnings, the type of operation, and sometimes where offices are located. There's a lot of factors. It's not just one. But I think when you incorporate these factors into the legal practice, I think you can see where some of the issues could come up, but also where there's opportunities to grant accommodations because of the way the factors would come down on the size of the employer or the resources of the employer. But yes, there will be some times where an accommodation will present an undue hardship. And more likely, these are going to happen in very small firms with very limited capacity. But it doesn't mean that that they can just be denied. We have to go through the exercise. But just pointing out how these kind of shake down. But certainly, they could be granted. Next slide, please. And I think really critical, as we've been talking about the rights of persons with disabilities, is also to know that another right we have under the FEHA is the ability that the employer and the employee need to get together for what's called an interactive process. It must be initiated when the applicant or the employee requests an accommodation. It's really this coming together to see if we can grant the accommodation or find alternatives that will be equally effective for the employee. And the employer must also initiate an interactive process when they become aware of the need for an accommodation. So this also goes to our point two of the culture of the law practice, and realizing that if the employer is aware that an employee, a lawyer, is struggling with a disability and it's impacting their work, and they're aware of this, they need to initiate the accommodation process and say, boy, let folks know that they have these rights and that they can avail themselves, and if there's an accommodation that may be needed. Very important. Next slide, please. And the interactive process is this like good faith, meeting between the employer and the employee to really try, or their representative, to try to see if we can't find an accommodation that's going to work, or maybe the proposed accommodation will be just fine. But it's critical that both sides engage, and for an employer not to do this and just say, no, I'm not granting the accommodation, that's actually a violation of the FEHA. We need to go through this process, and this is where both sides can come together and we can actually learn what each other needs and how we can get there. And it can't be delayed, and we need to provide the documentation and the information exchange to make this happen. Next slide, please. Now, as I said a little bit earlier, an applicant or employee with a known physical or mental disability or medical condition If they request an accommodation, we're going to need to have the interactive process. And if the employer or law firm doesn't do that, then that's a separate violation. And the employer or other covered entity, if they become aware of this need of the accommodation, even by a third party, we need to initiate it. So just again, it's not something that always is going to be happening from the employee side, but the employer may be aware and has a duty to initiate the interactive process. Next slide, please. Now, this can also come up too, where, as Wendy was talking earlier, where we have, employees or lawyers who have been out of work for a considerable time, and maybe they've exhausted their time under the California Family Rights Act, which allows 12 weeks of job protected leave to care for yourself or for yourself in this regard. And let's say that's happened, again, the employer is going to need to offer up a reasonable accommodation, engage in the interactive process, because there may be a need because they're now disabled. And I just think that comes up a lot in the practice, where someone may be out and you're like, oh, so-and-so's out, they've been ill, but actually they have a disability and they're going to need an accommodation, which may be more time to recuperate or other types of accommodation. Next slide, please. And I think the goal of this process, of the interactive process, to remove barriers that keep people from performing their job that they could do with some type of accommodation. And I think for us lawyers, that's a big piece, that if we obtain some accommodations, if we have a disability, we could be able to do our job in a way that is less taxing to our disability and allows us to thrive. Next slide, please. And I just threw these in just real quick about what's the word on psychological examinations related to disability and inquiries during employment, because I think this is always a concern of attorneys. But an employer or other covered entity may make disability related inquiries, including fitness for duty exams, and require medical examinations of employees, so long as the inquiries are both job related and consistent with business necessity. And business necessity in the regulations means, regarding a medical or psychological examination, means that the need for the disability inquiry or medical examination is vital to the business. So in many businesses, it's not vital. Some it may be. Let's go to the next slide. But, and this is key, but the FEHA does prohibit employers from either verbally or in writing requiring any medical or psychological examination or related inquiry of any applicant or employee prior to making an offer of employment. And then again, it prohibits inquiring directly or indirectly as to whether the applicant or employee has a mental or physical disability or medical condition. And then inquiring about the nature and severity of a mental or physical disability or medical condition. So there are limitations that the employer has to abide by. Still doesn't prevent the interactive process from occurring, but we can't get in and say, oh, if you have a severe mental health disability, as I define like this, I'll never hire somebody. That would not only be straight up discrimination, but it could also relate to a denial of a reasonable accommodation. Next slide, please. Now, remember, an employer may inquire into the ability of an applicant to perform job-related functions and may respond to an applicant's requests with either with or without a reasonable accommodation, right? So that is fair. And once an employee's offer has been made to the applicant, but before the start of duties, an employer may require a medical or psychological exam. However, the examination or inquiry must be job-related again and consistent with business necessity, and all entering employees in the same job classification must be subject to the same examination or inquiry, not just someone because they identified as a person with a disability. It needs to be across the board. Next slide, please. And I'll just leave with this case that we did, and really, I want to really focus our attention to the policy in this case, where we had a case of disability-based discrimination in the workplace. Someone requested an accommodation, essentially was denied. But what came out of this case was we found out that the employer had a policy of a quote unquote fully healed policy, saying, employee, don't come back to the workplace until you are quote unquote fully healed. Now, with everything we've heard before, folks with disabilities are never going to be quote unquote fully healed. They're always going to have a disability or disabling condition. And I think this case stands for this idea that there's rights for persons with disabilities in the workplace, and they don't have to reach a threshold of being disability free to be able to be thrive in the workplace and be allowed back. And so I think with everything we've said, I just think this is important to know as attorneys, that we do have rights, that they're critical rights, and that we should avail ourselves of them in order to really thrive in our jobs and to be able to represent our clients to the best of our ability. Because when we're not doing it, I mean, that does bring up other issues of how we're impacting others when we're not requesting accommodations and doing the things we need. So I'll leave with that, and I'll pass it on, and thank you so much.
Thank you, Branden, so much. I want to just let everyone know, we will be stopping on time at 11:45. So we have 15 minutes left, and we're going to bring everyone in now. We're going to do our hypothetical. We probably won't get to all of them, but we'd like to start with our first hypo. And hopefully we'll get some discussion going on this. If we have time, we'll certainly move to our second hypo, but this is a great hypo that kind of segues right from what Branden was just talking about. So I think we can see most people. Let's see. Yeah, so perfect. We have the right view on. I am going to let Beth Mora, who actually drafted a lot of these hypos, go ahead and introduce the hypo to us. And are you going to be showing that on the screen, or we're going to just read that out loud, Beth? Excellent. Okay. So this is the hypo for everyone to see, and then I'm going to go ahead and let Beth take over with this.
Yeah, thank you, everyone. And this follows beautifully after what Branden just covered at the end. Unfortunately, it also follows beautifully for attorneys. I get this question a lot for attorneys. Attorney is undergoing treatment for anxiety. I don't know one attorney who probably couldn't have this issue in their time in practice. Attorney attempts to maintain privacy as to their weekly appointments, including scheduling them as late in the day as possible. However, within a month after starting treatment, it becomes clear it's difficult to maintain a weekly appointment. Attorney is unsure about seeking an accommodation to leave work every Tuesday at 4:45 for that appointment, and what they would have to disclose to do so, and is fearful that they would be subjected to discrimination or retaliation for seeking that accommodation. Obviously, they're fearful of seeking an accommodation, disclosing a disability, and most importantly, disclosing a mental health disability. That is just layers upon layers of concern for people. And so the first question we are asking is this a disability? The next will be, is this accommodation, a reasonable accommodation? And what would the attorney need to do to provide for that? Does the attorney have to disclose their request is for a mental health condition, therapy appointments, and is it reasonable for them to fear discrimination and retaliation? And so we're welcoming comments in the chat for the first question as we work through it, and also if you want to unmute yourself if you're allowed to. And I'm going to stop screen sharing. I'm going to cut and paste the questions in the chat as well to make it easier for you. Can they unmute themselves?
Yes, everybody should be able to unmute themselves. If you can't, just throw something in the chat and I will get the tech person to fix that.
Well, while we're waiting for folks, I mean, should we opine a little bit, Beth?
Oh, please go right ahead.
Well, I mean, I think as to the question of is it a disability, I would just remind folks that, it's just a limitation to a major life activity. And certainly, I think the hypo was anxiety, related to a mental health condition, would be that, a major life activity of would equate to that.
Would everyone agree this is a disability? I would think so. Okay. And is it a reasonable accommodation to ask? Oh, Marta.
I think even if it is not, whose risk it is to say it's not. So if I were the employer, I would be like, well, I don't know, your limitations are, I mean, I don't even think that the question is this a disability or not? The question is, what are the limitations that the employer need to accommodate? Because I don't think that the question would come down to, is this a disability or not? In a sense, like risk aversion is our middle name, right?
Okay. And do you think it is a reasonable accommodation to leave every week, once a week at 4:45?
Why, if the doctor says so? I think what this employee needs is a note from the doctor saying this employee needs to be seen every week at 4:45 p.m. on Tuesday, and that is the limitation. And it doesn't have to have a reason. It could be physical therapy for all I care.
And what do you think? And the doctor's note, do you think the attorney would have to provide anything else but a doctor's note?
No, I mean, if we are like grilling me, no, I think just the limitation. Like I even tell my clients that your employer is never entitled to your private condition unless it is pregnancy, because that is in its own category. But other than that, it is a major medical condition, and just a note from the doctor that this employee needs to be seen for an unlimited time intermittently would be sufficient. And if the employer doesn't do that and asks for the condition, then they are putting themselves at risk.
Well, how about this? And I saw Maureen, you unmuted yourself, so I don't know if you were going to say something, but when someone turns in a doctor's note, it does tend to identify who the doctor is. And then the employer can Google the doctor with their address. So a lot of people who turn in a doctor's note for a mental health condition often worry that the employer can then verify that they're seeking help for a mental health issue. What would you say then to the employee seeking assistance, attorney seeking assistance? Anyone have any thoughts on that?
Well, there are no magic words that are required in order to seek an accommodation. And actually, you don't even have to identify your medical condition. I find in representing, because I do represent tons of clients related to disability, discrimination, harassment, and retaliation in the workplace, that as an evidentiary matter, I like it to be in writing, and I like it to be more expressive, just so that there's no conflict down the road about knowledge and notice that the individual has a disability and requires accommodation. But technically, that's not required under the law.
Thanks, Wendy. Anyone else have any thoughts on this hypo?
We have a question in the chat.
Yes, can a disabled person push back against the employer's requirement for a doctor's note?
Why would you do that? Why would you want to? Why would you want to do the only thing that you need to do is provide a note of your limitation, nothing more? And that in regards to what type of doctor it is, mental health professionals see a lot of people with actual physical pain. For example, fibromyalgia is treated by psychotherapists who prescribe SSRIs. So it's really the employer is in no business second guessing what type of condition this is. It also kind of weirdly reminds me of this Sopranos fact pattern that, you know, and nobody should know that you are seeking a shrink, but there was a little bit of thing about the confidentiality of what was disclosed in the psychotherapy that was kind of overcasting that fact scenario. But here, if you are worried that they are going to retaliate against you for you having a mental disability, I'm saying, let's go. Let's retaliate. Let's see if they retaliate against you. I buy a boat. I buy a weekend house. You're going to go and retire early. Like, let's do this. Like, what's the risk?
So Joan, I think your question though is correct, is that if the person's worried about retaliation, the less information they provide, that may be what they're trying to do, is protect their privacy. What Wendy brought up is an important point. If they're worried about retaliation, they want more data out there to say that they've triggered their protections. It is a very difficult line to draw, and you never really know where to put it. And so that is difficult, and they can push back, but so can the employer. But here's another hypothetical for you all that talks about how much data they have to provide, and it's job related for all of us. I will show you here. Attorney placed on doctor-ordered bed rest due to high-risk pregnancy, a disability. Attorney seeks a stipulation from opposing counsel to continue trial. Opposing counsel refuses and suggests attorney have another take over the case. Attorney files a motion for continuance, noting her pregnancy-related disability and that no previous continuance has been sought. During oral argument for the motion, the court questions why attorney's second chair, a significantly junior male associate, was not able to take the case to trial in her absence. What do you see? Is this a disability? Is this a reasonable accommodation? What, if any, actions could and or should the attorney take if a motion for continuance is granted and or denied?
I will tell you that I have heard from many of female colleagues who've experienced this exact scenario, as well as issues regarding breastfeeding and needing time for maternity leave, that this has been, unfortunately, a major issue for female litigators in the law. It is a disability. It is protected. And from my perspective, the question itself of why a male who's significantly junior and, you know, is not lead trial counsel, that in itself raises also issues of gender bias. Generally speaking, the junior trial attorney, you know, they're learning how to do a trial. They would not know how to put on a trial, generally speaking, and it could be a significant injury to your client to not have an attorney with the requisite experience. And I would recommend that before individuals seeking paternity leave or maternity leave or family, you know, bonding leave, child bonding leave, if you're going into court for these things, make sure you have a court reporter, get a record of what's going on. There have been colleagues of mine who've had to file writs related to this issue. If anyone needs a copy of such a writ, if they're in that situation, feel free to contact me, because having a record is extremely important.
So I'll just add to that even further and take this a step farther, which is, I don't care whether it's a junior male associate, whether it's a female equal associate, no one has the right to tell me as a disabled lawyer who should be doing my job. I can do it. And just because I have limitations and need to request an accommodation, the answer is not, oh, let's have someone else in your firm do it so we don't have to accommodate, so we don't have to continue the trial, or so we don't have to shorten a deposition. That's not the answer. The answer is, I'm the lawyer on this case. The client's requested me. This is my client, and I'm going to defend this case, and I have every right and capability. So regardless of who's making this, who is going to replace me with this suggestion, whether they're a junior associate, a female or male, no one should be replacing the lawyer that's requesting the accommodation. That is not a reasonable accommodation. That is very, very demeaning to someone with a disability. So I think that's important to note as well. I also want to say we have 2 minutes left, and as the moderator, I have to keep to the time. So who else, does anyone else have anything that they would like to say so that I don't get, what shall I say, chastised by the people, so to speak, at CCBA? Want to keep on schedule. Anyone else?
I'll just say that, you know, remember that the protections for persons with disabilities, you know, does extend to our state courthouses, federal courthouses. And, you know, for example, if someone had a service animal, an attorney, you know, someone can't, it's the same kind of thing, you know, when an accommodation is an accommodation, whether it be, you know, a time off for a serious health condition or need a change in the schedule or what have you. And I do think this is one of those issues where it seems kind of gray, but it's really not. It's there. It needs to happen. That can do the weighing and go through the same abilities that have to happen. But I do think there's been a long time issue around access in the courts, and I think it's something that, you know, it's a good conversation to continue, not only with what you bring up, but with other issues that have happened over the years.
Thank you, Branden. If anyone has any further, the materials are in the materials tab. If you have any follow-up questions, want to contact any of us, our contact information is on the PowerPoint. Thank you so much for joining us today, and we wish you the best moving forward. Have a great Thanksgiving. Thanks.
Thanks, everybody. We've got our
Bye-bye.
keynote with Dean Chemerinsky in 15 minutes. Have a great rest of your day.
Thank you, Brandon and Wendy. Thank you, Julianne and Teresa.
Now,
And thank
fantastic
you,
job,
Beth, for filling
speakers.
in at the last minute. Really appreciate it. You're awesome.
Thanks. I'll see you next week at the clinic.
Okay.
Wendy, thank you a million.
Oh, thank you.
Fantastic speaker. I enjoyed working with you.
Yeah, I
Really
love
appreciate you guys did a great job being flexible with this. You just
Yeah. This
went
was
with the
great.
flow so well. Very professional.
It
Thank
turned
you.
out perfectly with all of the changes. Presentations were great. Great flow.